Hello everybody and welcome to our webinar on effective asset protection. My name is Adrian Bailey and I'll be moderating or hosting the webinar today, which will be presented by Kate Salkeld. You may be thinking to yourself, who is Kate Salkeld? Well, she's Kate Chalker under her new married name. So I'm sure you know her now, and if you've been to our webinars before, you know that she is an excellent presenter. Before Kate jumps in and tells us all about effective asset protection, just a couple of housekeeping matters. If you want to download a copy of the slides, if you click on the Files button, you'll be able to download a PDF version of the slides today. If you have any problems with that, just let us know and we can send you a copy. The presentation today will be recorded and will be uploaded to our YouTube channel sometime in the next couple of days. So if you have to duck out or if you miss part of the presentation, you can always go to YouTube from about next week, I'd say, and recap on the presentation. Bearing that in mind, because it is recorded, we will be having questions both during and at the end of the presentation. But in your questions, if you could obviously keep them anonymous in terms of client details and so forth, I'll vet them anyway, but just a reminder in relation to that. On questions, if you want to put them into the chat message box, I'll pick them up and ask Kate at an appropriate time, either during or at the end of the presentation. So I'm going to tune out and hand over to Kate. Thanks, Kate.
Thanks, Adrian, and good morning, everyone. Welcome again to our webinar today on asset protection. Those of you who have been with the firm for a while know that asset protection has always been a pretty large part of the type of work that we do. But we're finding that increasingly so over the last couple of years. We've got a lot of clients concerned about protecting their assets, particularly in the context of all of the economic and financial turbulence that we've had over the last little while. So in today's webinar, we'll be looking at some of the threats that clients are facing at the moment in terms of protecting their assets, and some of the different strategies that we can implement to make sure that they are protected against creditors. So just in terms of a bit of an agenda for today's webinar, as I mentioned, we'll be looking at the different types of threats, the different entities or different things that have people concerned about their assets. Then we'll be looking at a particular strategy that we often implement to safeguard these assets from attack. We'll be looking at something that can interfere with the effectiveness of these strategies, being the clawback provisions that exist under the bankruptcy legislation. We'll be touching on those. We'll be looking at how you actually enforce these types of strategies in the litigation process and how it actually plays out. And also we'll be looking at some of the things that can go wrong when trying to implement an effective asset protection strategy. And we'll be looking at a couple of recent cases in that regard. All right, so some of the key threats that have people concerned about the protection of their assets. Of course, the main one is normally the threat of bankruptcy. So that's when a person is not able to meet their debts as and when they fall due. There's often a judgment made against them. They don't pay that judgment, and then someone makes an application for them to be made bankrupt, or you can also do that voluntarily. And that's when a trustee in bankruptcy would be appointed to step into your shoes and basically to work out what assets you have, what creditors you have, and to administer your bankrupt estate that way. Not an easy or a pleasant thing for an individual to go through, and often it's a case of last resort in terms of a person going bankrupt. So that's normally the predominant threat that a person is worried about. But other potential threats include the family court. There's the risk there of a relationship going sour and a person and their spouse ending up in the family court, with the family court able to make orders as to the division of assets. That's another key threat that people are concerned about. other potential claims or disputes that can arise, which may or may not end up in bankruptcy, depending on how they play out. Of course, if you're in business and you're in a partnership, or you may be a shareholder in a company or a unit holder in a unit trust, you go into those types of structures with good intentions, but of course things can go wrong and there can be disputes with your fellow owners. So in that case, there may be a dispute that ends up in court, which could result in a judgment being handed down, and that could potentially result in bankruptcy for an individual. You've also got the threat of a deceased estate dispute. So you may have a family provision application being made where a potential beneficiary says, I feel I've been hard done by, I've been left out of this estate, or I haven't been left enough out of this estate, and that could turn into a nasty legal battle. Another potential threat is that of director liabilities. We know the risks that come with being a director in terms of all of the fiduciary obligations that directors owe to their shareholders and to others. But there's also the risk of DPNs, and certainly the ATO is really clamping down on those types of issues in serving DPNs and also garnishee notices. So if there is a company that a person is a director of and they've got unpaid PAYG or superannuation or even GST, there's a risk that that liability could be passed on to the individual director and could result in them being made bankrupt by the ATO if they fail to pay that amount. And then, of course, just generally the Commissioner of Taxation, if there are unpaid tax liabilities. And I've got some statistics on the next slide in terms of general bankruptcies and also company insolvencies. I don't have any particular statistics on the ATO, but I'm sure you've all noticed as well that over the last probably 12 months or so, the ATO has been really aggressive in pursuing a lot of historical tax debts that have sat there for quite a while. There's obviously been a directive somewhere within the ATO to pursue these debts quite vigorously. And so we're seeing a lot more people being sued by the ATO or having other legal disputes with the ATO because of these types of debts. And so that's quite clearly a large threat for many people. Okay, so I did some research, and this is coming off the back of discussions with insolvency practitioners that we have contact with that are saying that, you know, the last 12 months or so, they've been as busy as ever, and they've got an increasing amount of work coming their way. So insolvency is obviously on the rise in Australia, and so this information is taken from a report prepared by the Australian Financial Security Authority, AFSA, that look after bankruptcies and other insolvencies in Australia. And this is based on data that they had up to the end of the 2024 financial year. And so they have reported that there were 11,644 new personal insolvencies, so bankruptcies, in the 2024 financial year, which is up just over 17% from the previous year. And they forecast that this rise in bankruptcies will continue over the next 2 financial years. So they're predicting that the number of bankruptcies will rise to 13,400 in the 25 financial year, and then up to 14,950 in the 26 financial year. So that's clearly a fairly significant growth in the number of bankruptcies that we're seeing each year. And that's underpinned by the fact that we have a pretty large credit system of $3.6 trillion in Australia. A couple of interesting statistics on the profile of the different debts that are giving rise to these bankruptcies. Nearly half of the debts were fairly small in the grand scheme of things, under $50,000. 28.3% of all of the debts, or all of the bankruptcies rather, were over $100,000, with the balance being between that $50,000 and $100,000 mark. But interestingly, the dot point at the bottom says that individuals who were in business themselves only accounted for roughly a quarter of all the bankruptcy filings, but the amounts that were involved in their bankruptcies accounted for 3/4 of the total debt. So that clearly shows us that there's a fair amount of risk when dealing with business, and large quantums of debts that can arise from those businesses. Up the top there, I've got some of the top creditors that AFSA reported, and there's no real surprises there, being the ATO having $2.5 billion worth of total claims against individuals, and also the big four banks looking at $2 billion between them. And just another interesting little tidbit, the last dot point on the screen, showing that there's about 9 insolvency firms within Australia that manage about 75% of all cases. So they're the big players in the area. So that report was looking at personal insolvencies, bankruptcies, and those statistics show that bankruptcies are growing in Australia. And the situation is much the same when we look at companies. So this is data taken from ASIC in terms of company insolvencies. And so we can see from between about 2016 to 2019, it was fairly steady, probably a little bit on the decline. Then, of course, we had COVID during 2020, 2021, and we had those COVID measures in place. We had that moratorium on new insolvencies at the time. But we can see that after COVID, from 2021 onwards, we've had a very sharp increase in company insolvencies. So you can see in 2025, we're well above the position that we were at in 2016. So much like individuals, we've got a lot of companies going under, going insolvent, and that's also projected to keep growing and increasing in the years to come. So what are some of the reasons why we're seeing this increase in personal and company insolvencies? And that all comes down to, as I mentioned at the start, all of the financial and economic uncertainty that Australia and really the rest of the world has been experiencing in the last few years. Of course, we've had the high cost of living that people have been struggling with, and we've had persistent inflation occurring, which has meant that household budgets are struggling to make bills and to pay their rent, etc. We've also got interest rates remaining high because of that inflation. We've seen, obviously, a cut by the Reserve Bank, and there may be some more cuts to come in the coming year. But those changes may take some time to have any impact on people's cost of living and their ability to pay their debts. Another reason would be increase in unemployment. It's projected to reach 4.5% by next year. Because of the issues with cost of living, we've got people's savings balances declining, especially where people are renting their homes or where they're carrying on a small business. We're seeing increasing cases of people defaulting on their loans, which is a sign of deeper financial stress that they may be experiencing. And then lastly, we know that COVID was 4 or 5 years ago now, so all of that support has long gone, and we're still really seeing the effects of what people went through during COVID and the economic decline there. So those are some of the reasons why we're seeing such an increase in personal and company insolvencies. So with that, obviously a lot of clients are seeing that on the news, and they're becoming concerned for their own asset protection and what may happen to them in the future. So that leads clients to come to us and ask about, what can I do to protect my assets? And really, when we talk about asset protection, what we're referring to is really separating value in a person's assets from risk or from attack by creditors. So ideally, what you want to have in a well-structured asset protection structure is you want the assets or the value in a person's assets to be held in one entity or multiple entities that are what we call safe havens. They're passive entities. They're not exposed to any trading risk. So the likelihood of them being sued is very low. And you want to have those entities separated from any risky entities, such as any trading entities, or if you're an individual that's in business or that's in a risky profession, you would want that individual to be separated from the wealth. Another aspect of asset protection that we really try to utilize to our advantage is trying to have a related entity take a priority position in terms of your assets. And what I mean by that is, if the worst comes to the worst and a person ends up going bankrupt, you want to have a related entity in a position of priority that has enforceable security over your assets to be able to recoup that value if things do go south. So in terms of the traditional solution, traditionally the solution has been to hold your assets in a discretionary trust. And that's because generally discretionary trusts have been very successful and very effective in terms of protecting a person's assets. The courts have recognized that even if an individual is a director of the trustee company, even if they're a primary beneficiary and they're a principal of the trust, they can be within all of those different roles. But if something happens to them personally, they get sued in their individual capacity, that's not going to expose the assets of the trust. And that's why discretionary trusts are so popular in this area of work. And there's nothing wrong with that strategy in terms of having all of your assets owned within a discretionary trust. However, the issue that people often encounter with the traditional solution is the tax impact. And that's because often when we're dealing with clients, the main asset that they own and the main asset that they're trying to protect is their family home. And we explain to our clients that you can transfer your property to a discretionary trust, or you can purchase your home in a discretionary trust, but there's a fairly significant tax cost that will come with that solution. First one is land tax. We know that if a person owns a property in their own name and they're using it as their principal place of residence, they're not going to have an ongoing land tax liability. However, if it's owned within a discretionary trust, even if that same person is living in the property and using it as their main residence, because it is held within that trust structure, they're not going to get that land tax exemption. And so every year that trust will have a land tax liability for that home. And that liability itself can be very off-putting for clients. Another tax cost would be stamp duty, and that would be where an individual already owns a property in their personal name and they're thinking of moving it into a discretionary trust. Even though they're effectively wearing both hats on either side of the transaction, it would still be a dutiable transaction and there would still be stamp duty payable by the trust on the market value of that property. and I live in Sydney, so I see a lot of very high property prices, and so transferring a family home to a discretionary trust, the stamp duty alone is enough to put people off that solution. And the last tax cost that we would need to deal with is CGT. If we are moving a property from an individual to a trust, it shouldn't cause any CGT issues because they should be able to apply the main residence exemption. But there could be issues if the trust wants to sell that property in the future, because much like the land tax situation, if the property is owned within a discretionary trust, the trust will not get the benefit of the main residence exemption, and so you'll have that CGT liability to bear within the trust. So, as I said, discretionary trusts are excellent in terms of effective asset protection. It's just for a lot of clients, it's not really practical or workable from a tax perspective, particularly when we're dealing with the family home. So, do we have any particular strategies that can be used to still achieve asset protection without those negative tax consequences? What we often use for clients who are trying to achieve this is what we call our secured debt strategy. And this involves, rather than moving the assets themselves, it involves protecting the equity or the net value of those assets that are owned by the risk individual. So, like it says on the screen, it involves restructuring the equity that was used to purchase the assets to a safe haven entity, which will ordinarily be a discretionary trust. And the advantage of using this strategy is that there's not going to be any tax consequences. So there won't be any tax consequences when implementing the strategy, but there also won't be any ongoing tax consequences in terms of land tax or CGT, because the assets aren't actually moving. The assets are staying where they are. It's just a movement of the value that we would be dealing with. Clawback provisions would apply to this type of strategy as with any type of asset protection work, and I'll come back to those a bit later. Sorry, just jumping forward a little bit to the diagram. So this is how we implement our secure debt strategy. We have the individual on the left. Let's say they own a property and they've got some equity within that property. How it would work is that they would make a gift of their net equity in that property to a discretionary trust that they control. And this gift would be implemented by what we call a bearer promissory note, which is a legally enforceable two-person check, because we recognise that in most situations, people don't have that cash sitting in their bank account. Their equity is normally tied up in assets. So we use a bearer promissory note to document the gift of that equity. So that value moves from the individual to the discretionary trust, and then the trust will lend that amount back to the individual. And just as if the trust were a normal lender, a normal bank, that will be documented under a loan agreement, and the trust will want to take security for that loan. So the trust will take security in the form of a mortgage over any real property, or if we're dealing with personal property, such as shares, units in a unit trust, motor vehicles, etc., we would have a security deed, and ideally that would be registered on the PPSR. So that's how the strategy works. We do have similar types of strategies when we're dealing with companies or trusts that have valuable assets held within them that are exposed to risk. Similar type of thing, except when we're dealing with a trust, we've got a distribution, a capital distribution of that amount. When we're dealing with a company, we've got a gift of that amount by that company to another company, so as not to create any Div 7A issues. But other than that, the strategy is much the same, whether we're dealing with an individual, a company, or a trust. But I'm predominantly referring to individuals during the webinar, just for ease of understanding. So in a nutshell, that's how the strategy would work. There's a couple of different variations as to how it would be implemented, just depending on the timing of when we look to introduce the strategy. So if we're doing it before the purchase of an asset, rather than using a bearer promissory note, you would basically have the client identify what the net equity is needed to purchase the property, and they would make a gift of that money. They'd transfer that cash across to the discretionary trust, and then the trust would lend that money from there back to them for the purchase of that asset. As opposed to if we're dealing with a situation that's post the purchase of an asset, that's normally where you would be using the bearer promissory note to protect the equity or the value that's already tied up within that property. All right, just a comment here on increases in equity. The traditional solution that I spoke about before in terms of purchasing assets in a trust or transferring assets to a trust, that's more of a one and done solution because you're actually moving the assets into that safe haven entity. You don't quite have that same luxury when you're dealing with the secured debt strategy because the assets are staying where they originally were. So you've got the significant tax saving that comes with that, but the drawback is that we just need to make sure that we're accounting for any increases in equity that happen over time. So our rough guide is to have a look at the secured debt strategy every 3 years or so, have a look at the value that was gifted by the individual and then lent back by the trust, and look to see if that's still representative of the net equity that that person has. Often 3 years is a good amount of time to see values increase, and also if there's a home loan, if there's debts owing to banks, good amount of time for some of that debt to be paid off. So if there were to be an increase in a person's net equity, what we would do is just do a top up of the gift and loan back transaction. So the individual would make a further gift of the increase in equity to the trust, and then similarly, the trust would loan that amount back to them. Of course, if there is a property boom or some other circumstance that significantly increases the net equity position, you can, of course, do it more often than the 3-year mark. But as I said, that's just our rough guide of when it's a good time to look at that figure. And that's to make sure that the highest value is protected at all times if there were to be a claim made against the individual or if there were to be some kind of dispute. So the end result of implementing our secured debt strategy is that the individual, the husband and wife, whoever it might be, they remain the owners of the property. However, if they owned a property worth $2 million at the start of the process, at the end of the process, they would have a corresponding $2 million debt owed to the family trust. So their net equity position would be nil or as close to nil as you can get it. And so that gives you a lot of bargaining power to say to creditors, if things were to go wrong, yes, I do own this property. However, I've got this debt owed to this trust, which takes up all of my net equity. I'm really worth nothing. And that amount would be secured by a mortgage over the property or by a security deed over any personal property to give the trust enforcement rights of that debt. And the bonus of all of that is that there's no tax consequences. There's no improvement of the individual's tax position, but you're not having any negative consequences in terms of land tax, CGT, or stamp duty. One question that we often have from clients that are looking to implement this type of strategy is where they've already got an existing mortgage on title. So they already own a property, but it's mortgaged to one of the big banks. And often the question is it still possible to implement the strategy and to register that mortgage on title? And the answer is yes. It just means that we need to get the consent of the existing mortgagee before we can put that mortgage on title. So it's just a little bit of extra red tape and a little bit of extra paperwork in terms of getting that across the line. But it's more just a matter of explaining to the bank that it's being done for asset protection reasons. It's not a case of the individual is struggling financially and has had to take a loan out from another lender. It's not that case at all. It's just a matter of putting it in place for asset protection purposes. And the bank will often want the individual or the second mortgagee to sign a deed of priority, just to confirm that if there were to be a default on the loan, that the bank would need to be paid out first. And it's always going to be that way. There's really nothing we can do to get around the fact that the bank already has that security over the property. So it's not normally an issue in terms of getting that registered on title. It just depends on the particular lender that we're dealing with in terms of time frame for getting that consent. But if it were to be slightly delayed in terms of getting that consent from the bank, the mortgage can be put on at settlement or it can be put on after settlement. There's no complications there. Okay, I mentioned that this type of strategy and all types of asset protection work, they can be impacted by the clawback provisions under the Bankruptcy Act. So the clawback provisions, they basically allow a trustee in bankruptcy to look at the transactions that have gone on, and if the trustee in bankruptcy has the power to, they can unwind that transaction and they can bring those assets back into the bankrupt estate. So we need to be aware of these provisions, particularly in terms of the different timing provisions, with the end result being that it's definitely better to implement this type of work sooner rather than later. So the first clawback provision that we need to be concerned about is the one under Section 120 of the Bankruptcy Act for undervalued transactions. And this is going to apply to all types of asset protection work. And it applies where you're making a transaction for less than market value. So you're giving assets or you're giving value away from yourself to another person or another entity, and you're receiving less than market value for that asset or for that value. And that would obviously apply to our secured debt strategy because the individual is making a gift of their net equity to the trust, but the trust is not paying them anything for that gift. So definitely less than market value, meaning that Section 120 would apply. And because that section would apply, what it means is that if the individual were to go bankrupt within 5 years of implementing that structure, the trustee in bankruptcy could potentially unwind that transaction. In most situations, we can apply the third dot point here, which says that the normal 5-year clawback period is reduced to 4 years if the individual can prove that they were solvent when they made that gift to the trust. So effectively, it means that when a person implements the secure debt strategy, from the date of that gift, they need to make sure that they don't go bankrupt within 4 years of that date. Otherwise, they risk the trustee in bankruptcy applying Section 120 and unwinding the transaction to bring the value back into their bankrupt estate. The next clawback provision is Section 121, which is where you're entering into a transaction to defeat a creditor. So much like the last one, a trustee in bankruptcy would have the power to set aside or unwind a transaction where it can be shown that the main or the predominant purpose of that transaction was to defeat one or more creditors. Now, it's important to remember that that's referring to known creditors, not just contingent creditors. So if a person was a director of the company and they needed to give a personal guarantee to the bank or to some other supplier, for example, that's not going to count as a known creditor for the purpose of this section. It would only be if the company didn't pay what they were owing and the bank or the other person called up that personal guarantee. If that had already happened, or if a person was already being sued and they came to us looking to put some asset protection work in place, we would have to say to them, you can do it, but the very real risk for you is that the trustee in bankruptcy will apply this section to say that you only entered into this structure to try and defeat this creditor, so very likely to be unwound if they were to end up going bankrupt. And there's no time limit for this type of clawback provision. So we're not dealing with the 4-year period like we were with undervalued transactions. It's unlimited for Section 121. Another clawback provision is Section 121A, which deals with consideration being paid to a third party. So that applies where the payment is directed to a third party rather than the natural person that transferred the asset in the first place. And similar timeframes would apply under that clawback provision. We also have preference payments under Section 122 of the Bankruptcy Act. And so that's where a person is found to favour one creditor over another. So they pay one creditor that they owe money to, and they fail to pay other creditors at the same time, on the basis that a person who is going bankrupt should be paying their creditors equally. However, when we're dealing with these preference payments, there's only a 6-month time frame. So just because of how much shorter it is compared to an undervalued transaction, less likely for this one to be a concern. But certainly when we're looking at the clawback provisions, we need to be concerned about the 4-year ticking time frame for undervalued transactions, which is why I said it's important that we put this in place sooner rather than later, and certainly before a person gets into any trouble or any disputes with other creditors. All right, so I mentioned that we're going to take a look at some cases where things went wrong, and unfortunately our firm was involved.
Before you do, we've got some questions about the strategy and different aspects of it, if I'll just run through those now. First of all, a comment, some states do allow main residence and trust along with in-tax exemption. That's right, some states do, but the majority don't. Next question about secure debt strategy. Does the ATO expect one to charge a market rate of interest?
No, it's not necessary to charge market rate of interest. In most situations, we won't have any interest charged at all. Because it's not required for a loan agreement or for this type of strategy.
And a question, and recognising we're not accountants, curious as to the journal entries in the trust records. Debit loan owed by individual, credit, equity and trust. I'll answer that for you, Kate. Yeah, that's effectively it in terms of what the entries end up being. There's a question from Jason about the clawback periods, but you've covered that well. Question from Daniel. If property already encumbered by first mortgage to bank, can you still gift residual equity to trust?
Yeah, you can. Yep, you would look at the net equity. So look at the market value of the property, take off whatever is already owed to the bank, and whatever's left behind is what you can gift to the discretionary trust.
And one from Noel, a trust is usually commenced by a gift to the trust by an unrelated settler. Common practice then seems to be that the deeds exclude the settler. Under the secure debt strategy, the at-risk individual makes the extra gift. Are there any potential problems in extra contribution also being called a settled sum, and then potentially excluding the gifting individual from also being a beneficiary?
No, there's not. Sorry, just trying to read through that again. And certainly when we're setting up our discretionary trusts, the settler is a solicitor within the firm that's just involved with setting up the transaction. So that's not a concern in terms of the settler not being a beneficiary. But no, I haven't seen it treated as a further equity contribution.
Well, I guess it is an equity contribution. It's a contribution to equity, but it's not by the settler because the settler is a defined term within the deed. So there's no issues there. From Mark, presumably this requires a suitable valuation of the property.
Yeah, it comes down to a question of evidence. If the individual does end up going bankrupt and we're looking at defending or enforcing this strategy, it is a matter of being able to produce sufficient evidence to show that they did have that net equity in the property. So yes, certainly if the client has some contemporaneous evidence of what the value of those assets were, certainly helpful in terms of defending the strategy.
And once equity is gifted to the trust, can the capital and becomes capital or corpus, can the capital be distributed to beneficiaries without winding up the trust?
I'm not sure, Adrian. Do you mind addressing that one for me?
Yeah, if it's capital, it can be distributed without winding up the trust if there's a suitable capital distribution power, which normally there would be in most discretionary trusts. Is the executor of a bankrupt estate personally liable for debts of the estate? Normally, if the estate is put into bankruptcy, the trustee in bankruptcy takes over as executor, so the executor doesn't, the named executor doesn't actually administer the estate. If clawback period applied to divorce case where husband or wife transferred the principal home to spouse, I'm not quite sure, Kevin, if you could elaborate on that. I'm not quite sure where the question's heading with that one. And then the last one for now, Kate, from Kunal. In case of high-risk working spouse and low-risk non-working spouse, how secure is it to buy the house in the low-risk spouse's name? Can creditors come after the low-risk spouse, even if all funds used are from income of high-risk spouse?
Yeah, it can still be an effective way to protect assets to have them owned by the low-risk spouse. Issue we often see is that some people don't want to put it completely in the name of the low-risk spouse. They'll often want to keep a 1% interest in the property, for example, and that's when things can fall apart and get muddy.
All right, I'll tune back off, Kate, so you can keep going with the rest of the presentation.
Thank you. All right, so we're going to look at a couple of recent cases, as I mentioned, where things went wrong, and our firm was involved in both of these cases, unfortunately. But some people contact us and say, what do you make of these cases? Does it mean that the structure that I've got in place is no longer effective or it's no longer legally enforceable? And we still maintain that the structure is valid and effective. It's just, unfortunately, with these two cases, there were some issues in the implementation and also some issues with the conduct of the parties after it was implemented, which led to the effectiveness being compromised. But we certainly still maintain that you can implement this gift and loan back structure and that it can hold up in the event of a challenge. So the first one we're looking at is Pamuan number 2, which was a 2022 case. And this was a decision relating to costs of a matter where there was a gift and loan back strategy implemented to remove value from an individual's estate. And the purpose was just that, to reduce the value of their estate when they passed away, so that anyone challenging the estate would first have to deal with the liability to the trust. So that individual passed away, and their son was appointed as their executor and as controller of the trust. And effectively, it was done to leave everything to the son and to exclude the two daughters. There was an earlier decision, Permuin number 1, which related to a successful application to have the executor of the estate removed. It's quite an interesting judgment with a lot of colourful language extracted from some recorded phone calls between the executor and one of his sisters. And judging by the phone calls, it's probably not a surprise that he was removed as the executor of that estate. But following that, there was this number 2 decision, which looked at the validity of the gift and loan back strategy. And unfortunately, during that hearing, the court found that the documents were invalid due to a technicality, and the matter eventually settled by consent order. So with that one, it unfortunately came to light after we had been involved with the structure, that there were issues with the delivery of the promissory note. There were some issues with the dating of the documents and also the figures that were inserted. And coupling that with the behaviour of the client after it was implemented, that's what led to the court finding that the structure in this case was invalid. So this case really emphasises how important it is to precisely and effectively prepare the documents and have them executed. The other case here we have is Turner and O'Brien Turner, 2022 case. And this case had a long history involving asset protection of the father's assets. So the husband had given his wife a power of attorney, and she had subsequently used this power of attorney to transfer some land into her name, and also their children's names. The wife passed away, but then the husband, under his tutor, he commenced some proceedings to say that she had breached her fiduciary duties by making that transfer. And the court eventually sided with the husband to say that she had acted in breach of her fiduciary duties, and the children were ordered to pay equitable compensation. But we had implemented a secure debt strategy in this case, but where it all fell apart was that the mortgage over the property had not been registered, despite our many recommendations to make sure that it was registered on title. So I suppose the takeaway from that case is the importance of making sure that any security, mortgages or security interests on the PPSR, making sure that they are duly registered, because if the mortgage had have been registered in this case, then the transfer could never have been made by the wife. So they're the 2 cases that I wanted to mention, because we sometimes get questions from clients and accountants on what they mean for the strategy now. And yeah, they just emphasize how important it is to get the documentation right and to make sure that the security is registered, to make sure they do hold up in the event of a dispute or a legal proceeding. All right, noting the time, I'll just rush through these last couple of slides a bit quickly. But ultimately, if we put this strategy into place, we want to put it in place early to get past those clawback periods. And then if something were to go wrong, it's a matter of looking at how we can make sure it's enforceable. So we want to get outside that 4-year time period. If something happens during that 4-year time period, it is often possible to draw out the process to get outside that time frame. And 4 years does sound like a long time, but I'm talking about actually going bankrupt. And so for that to happen, you need to do something wrong. There needs to be a letter of demand. Then there will be a statement of claim. You'll go through the court process. There may be an appeal, and then you'll have them try to enforce their judgment. And then only after that judgment is not paid would you actually go bankrupt. So all of those steps take time. In that case, it would be a question of weighing up what's the cost of this judgment, what's the cost of maybe negotiating a settlement with them to make it go away, compared to what's the cost of paying lawyers, essentially, to drag out the process to make sure that the amount is protected should I go bankrupt. Another point there, that the last bullet point, on the slide, making sure that we are looking at the figure every 3 years or so to make sure that the amount is up to date and it is chopped up based on the current market value of the assets. That's important in making sure that a person's net equity is as close to zero as we can get it. All right, so in terms of the key takeaways for asset protection, as we've seen in the statistics, there's a lot of uncertainty in terms of economics and financial circumstances for a lot of people at the moment. So asset protection is a key concern. So what we would recommend for clients is that they get some proper legal advice prior to purchasing any large assets or the family home. And through our secure debt strategy, we ought to be able to set it up so that they can still maximize the tax concessions of owning a property, but still making sure that it is protected against creditors. Look to protect the equity in the assets rather than moving the assets themselves, so that we're not dealing with a CGT or a stamp duty liability. As we saw in Turner, make sure that we're always registering the security interest over the real property or the personal property. Yes, if you've already got another lender, it may take a little bit more time to get their consent to the second mortgage, but it's certainly worthwhile and recommended to go through that process. And lastly, make sure you're reviewing the work and the figures periodically, and also if they acquire any new assets that should be included in the structure, making sure to add those in as security as well. All right, have we had any other questions pop up, Adrian?
Thanks, Kate. We've got a couple. Recognising time, since I've had the opportunity to read them, I'll read them and answer them for you, if that's all right, Kate.
Sure, thank you.
Two of them effectively relate to what are the costs and fees. Short answer is it depends. The longer answer is more than happy to have a chat with your clients, as usual, at no cost or obligation, to go through the strategy and how it will work and costs. Like everything in life, there is a cost-benefit analysis in terms of whether it's worthwhile doing, and that's a decision only the clients can make. Question from Maria: when gifting property to a trust, does property title transfer from individual to trust? If you are gifting the actual property, yes, it would transfer. And from Liam, situations where it has been tested by court and was successful. In Turner, it was obviously a part of the court decision in terms of the strategy, even though the mortgage wasn't in place. To my mind, it was a bit of a red herring, because it was really more about whether the attorney had acted right or correctly in transferring the property to herself for no consideration. So that being said, obviously, often the question is going to be, does this work? The very short answer is yes, it does. However, if your clients get in a situation where they are challenged, any lawyer worth their salt on the other side is going to make all sorts of allegations and suggestions and tell you this doesn't work or that doesn't work. That's just part of the legal game, unfortunately. So I'd like to close off on behalf of Kate. Thank you, Kate. Once again, another excellent presentation. There will be a feedback email sent out after the webinar. If you could get some time, we'd love it if you could complete it. There's only a couple of very simple questions, most of which require you to just tick a box. However, one of the things is we ask for suggestion for presentations that you'd like in the future, because that's often how we decide what presentations we're going to run. So thank you again, and thanks to Kate for her hard work in preparing and presenting.
Thanks, everyone.